You wake up one morning and check your school email. There's a message from the Title IX office. It says, you've been named in a complaint for sexual misconduct, maybe sexual assault, maybe harassment, maybe something that happened weeks ago or months ago or even a year ago. You read it 3 or 4 times because it doesn't feel real. You might not even know what incident they're talking about, but the school is telling you that there will be a formal investigation. And if you're a parent watching this because your kid just called you in a panic, this video is for you too. Now your mind starts racing. Am I getting expelled? Do I need an attorney? Is this going to turn into a criminal case? What exactly happens next? If you've never been through this before, it can feel confusing, overwhelming, and honestly, terrifying. So today I'm going to walk you through how a Title IX case works step by step, what the process looks like from the inside, and what someone accused in that process needs to understand before they do anything. Hello, my name is Matt Wayman, and I'm an attorney with the Hammer Law Firm. Let's talk about what actually happens when someone gets pulled into a Title IX investigation. If you've just received that email, the first thing that you're probably feeling is confusion, maybe fear, maybe frustration, because you genuinely believe that you didn't do anything wrong. That reaction is completely normal. Most students who get pulled into this process have never been investigated before. They've never been part of a formal hearing, and suddenly they're facing a disciplinary system that's going to decide whether they stay in school. Here's the first thing you need to understand. A Title IX case is not a criminal case. You're not going to be going to criminal court. You're not standing in front of a judge, but the consequences can still be life-altering. Students can be suspended. They can be expelled. They can have a permanent disciplinary notation placed on their academic record, which follows them when they apply for graduate school, professional school, or jobs that run background checks. And here is something that a lot of people don't fully absorb the first time they hear it. In some situations, the same allegations that trigger a Title IX investigation can also lead to a separate criminal investigation that runs at the same time. That means that the decisions that you make inside the school process can have real consequences outside of it. We'll come back to that. Understanding how this process works from day one isn't optional, it's critical. So what is Title IX? Title IX is a federal civil rights law. It requires schools that receive federal funding to respond to allegations of sex discrimination. Most people originally heard of Title IX in the context of college athletics, but today it also includes allegations involving sexual misconduct, including sexual harassment, sexual assault, dating violence, domestic violence, and stalking. When a school receives a complaint involving one of those categories, it is required to initiate a formal grievance process to investigate and address it. That process is what this video is about. Every Title IX case begins with a complaint, often submitted to the school's Title IX office. The person making the allegation is called the complainant. The person accused is called the respondent. One thing that surprises a lot of people is this: the complaint does not require physical evidence. It often starts with nothing more than a written statement describing what the complainant says happened. That is enough to start the entire process. Here's something else. The complainant themselves don't even need to make the allegation to start this process. Sometimes it's a friend or a dorm's resident assistant who may have just heard something and reported it to the Title IX office. If the allegation is serious enough, the Title IX office may proceed with a formal complaint, an investigation, even if the complainant doesn't want that to happen. After the complaint is filed, the respondent receives formal notice, usually by mail. That notice describes the alleged conduct and identifies the school policy that may have been violated. At this stage, the rule requires that the respondent be presumed not responsible. The school is not supposed to treat the allegation as already proven. But here's something that a lot of students and parents are not prepared for. Before the investigation even gets going, the school may impose what are called interim or supportive measures. These are steps that the school can take immediately to manage the situation while the process plays out. Those measures can include no contact orders between the parties. They can include changes to housing assignments, class schedules, or campus access. In more serious cases, a school can temporarily remove a student from campus entirely. through an emergency removal process before any hearing has been held and before any finding of responsibility has been made. Those measures can happen within days of the complaint being filed because they can affect where you live, which classes you can attend, and whether you are on campus at all. Understanding the stage matters from the very beginning. One of the biggest mistakes that students make happens early in the process. They panic and they start talking. They message the other student. They text friends trying to figure out what happened. They go on social media, or they walk into the first investigator interview thinking it's just an informal conversation where they can clear everything up. But here is the reality. The moment the investigation begins, everything that you say becomes potential evidence. Text messages become evidence. Social media posts become evidence. Even statements made in confusion or frustration can later be interpreted in ways that hurt your defense. And remember what I said earlier about the criminal investigation running simultaneously to the Title IX investigation. If there is any possibility that this allegation can be picked up by law enforcement, what you say in the school proceeding can surface later in the criminal process. The most important thing that a respondent can do early in the process is stop communicating with anybody about the allegations. Save everything on your devices and understand the process before taking any action. Once the complaint has been filed, the school's investigators begin their work. They will interview the complainant. They will interview the respondent. They may interview witnesses. They will often collect digital communications, including text messages, emails, and social media messages. Both parties can also submit evidence that they believe is relevant, including photos, videos, messages, and witness information. This is perhaps the most important moment in the case. The investigator's report will be the foundation for everything that happens at the hearing. Responses to the investigator's questions must be clear and persuasive. The answers must accurately describe the respondent's story so that it appears in that report the way that it was intended. Our average client is less than 20 years old with no formal legal training and certainly no experience in handling Title IX cases. Without preparation and guidance, their responses to those questions are disjointed, unorganized, and often lead to unnecessary, incriminatory statements. We prepare our clients before the investigator's interview so they have the relevant responses to the important questions. This is also when evidence preservation becomes critical. Some students panic and start deleting things, text messages, photos, social media posts. But those communications might be exactly what the defense needs. Messages can show context that can contradict the allegations. They can support the position that what happened was consensual. Once evidence is deleted, it may be gone permanently. That can do serious damage to the ability to defend against those allegations later. Before the hearing, both parties are usually given the opportunity to review the evidence collected during the investigation. Interview summaries, witness statements, messages, photos, and other documents. This is where you start to see what the other side has said and where the witnesses in the complainant's account become visible. What a lot of people don't know is usually both parties are allowed to submit a written response to the investigator's report before the hearing. That response is an advocacy document. It's a real opportunity to challenge the evidence, point out inconsistencies, and frame the defense before the panel ever sits down. It should not be treated as a formality. What is the role of an advisor in this process? This is the part of the process that doesn't get enough attention. In most Title IX proceedings, both parties have the right to bring an advisor of their choice, and this advisor can be an attorney. I've already spoken about the advisor's role in preparing the respondent for the investigation. At the hearing stage, the advisor's role is especially significant. In Title IX proceedings, the advisor is the one that performs the cross-examination on behalf of the respondent, not the student, not the parent, the advisor. That means that if you walk into a Title IX hearing without an attorney as your advisor, you might end up with a school-appointed advisor, a professor at the school with no formal legal training, trying to cross-examine the witnesses against you, while the other party has experienced legal representation conducting their questioning of you. This is a real and significant disadvantage. It is also one of the most concrete reasons why having an attorney involved early, not just at the hearing, but throughout the investigation and evidence review stages, changes the outcome of these cases. Eventually, the case proceeds to a hearing, but this hearing is nothing like a criminal trial. There is no judge. There is no jury. The decision is made by a hearing panel or a designated decision maker, which might be trained administrators, faculty members, or outside attorneys hired by the school. The standard of proof is also very different from a criminal case. In criminal cases, the government must prove guilt beyond a reasonable doubt. In most Title IX hearings, schools use the preponderance of the evidence standard. That means that the panel only needs to find that it's more likely than not that the violation occurred. That is a much lower bar. And it means that the process is a lot harder to win for the respondent than most people think. During the hearing, witnesses may testify, evidence is presented, and the panel evaluates credibility. In Title IX cases, credibility is usually the central issue because there is usually no independent witnesses to the alleged incident. The panel has to decide whose account is more believable. That makes the quality of the preparation and the quality of the cross-examination extremely important. After the hearing, the decision makers issue a written determination explaining their findings, their reasoning, and whether the respondent is found responsible or not responsible. If the respondent is found responsible, the school may impose sanctions, including disciplinary probation, suspension, expulsion, or other consequences. Those outcomes can affect a student's academic record permanently, appear in background checks, and close doors in graduate and professional school applications. Most Title IX procedures include an appeals process. Appeals are limited to specific grounds, including procedural errors, newly available evidence, or conflicts of interest in the investigation or hearing. There is one thing that surprises a lot of respondents here. The complainant also has the right to appeal. That means that even if the hearing goes in the respondent's favor, there is still a stage where the outcome can be reversed. That is another reason why procedural errors and documentation matter throughout the entire process, not just at the hearing. Here's what I want you to take away from this. Title IX cases move fast. In the early stages, shape everything that comes after. The decisions made in the first few days, whether you contact the other student, what you say to investigators, what you do with your phone, have real consequences. The structure of the hearing means that walking in without experienced representation is a real disadvantage. And the preponderance standard means that the bar to find somebody responsible is lower than most people realize going in. If you or your student is facing a Title IX allegation, the time to get help is before the investigation gains momentum, not after the hearing date is set. Our firm handles Title IX cases. If you have a question about where things stand or what to do next, give us a call. The consultation is free. If this video helped you understand the process, please subscribe. We put out weekly content so people facing these situations can know what they're dealing with.